Order, and welcome to this afternoon's session of the Justice Select Committee, where we have the pleasure and the privilege of the Master of the Rolls and the Deputy Head of Civil Justice, that's Sir Geoffrey Birss, and Lord Justice Colin Birss, giving evidence as part of our inquiry into the County Court. Just before I ask our distinguished guests to introduce themselves, we need to do our declaration of interest. So if we can do that, beginning with Lindsay Farnsworth.
Good afternoon, my name's Lindsay Farnsworth. I'm the Member of Parliament for Amber Valley. My declaration is as per the website. I'm a non-practising solicitor formerly of the Crown Prosecution Service.
Good afternoon, I'm Pam Cox, MP for Colchester. My interests are as declared.
Andy Slaughter, I'm the chair of the committee. I am a non-practising barrister. I'm a patron of two justice-related charities, the Upper Room for Ex-Offenders and Hammersmith and Fulham Law Centre, and a member of the Unite and GMB trade unions.
Hello, I'm Sarah Russell. My interests are per the Register. I am a member of Usdaw and Community Trade Unions. I'm a solicitor. I hold a practising certificate, but I am not, in fact, currently practising.
My name's Tessa Munt. I'm the member for Wells and Mendip Hills in Somerset. Everything's declared on the register, but I would just add to the fact that I am a director of Whistleblowers UK, which is a not-for-profit organisation.
Hello, I'm Warren Dudgess, MP from Wolverhampton West. I specialised in personal injury and clinical negligence claims, working for Thompson Solicitors before becoming an MP. I hold a practising certificate, but I'm not practising at the moment. I'm a member of the GMB trade union and executive council member, and also a member of various APPGs.
Thank you very much. And just for the benefit of our guests and audience, this session is part of the County Court inquiry. It's slightly different from most inquiries in that our predecessor committee had begun this last year. The interruption of the general election means that we have decided to pick it up and to complete it, and therefore, as part of that, we're, I say, pleased to have the senior members of the Judiciary to talk to those issues. I'm very happy if either of you wish to make an introductory statement, or we can go directly into questions on that basis.
2 minutes?
Please.
Thank you. Well, it's very kind of you to invite us. We're very pleased to be able to talk to you. I have been Master of the Rolls and Head of Civil Justice since January 2021. And I was previously Chancellor of the High Court, which meant that I had responsibility for the business and property courts between 2016 and 2021. And I've been a member of the Judicial Executive Board since 2016. And as you probably all know, the Master of the Rolls is ex officio head of the Civil Division of the Court of Appeal. As Master of the Rolls, I'm also chair of the Civil Procedure Rules Committee, though Colin does most of the heavy lifting on that committee, and I'm chair of the Civil Justice Council. I'm also chair of the Online Procedure Rules Committee, something that I'm very committed to because I was heavily involved in its creation by legislation in 2022. I'm also second Vice President of the European Law Institute, and I sit on the steering committee of the Standing International Forum of Commercial Courts. And I just say that because I have wide international activity and engagement. I've been a member of the Law Tech UK panel since it was started in 2018, and I chair something called the UK Jurisdiction Task Force, which issues legal statements on the English law legal position affecting digital assets and smart contracts. So you may think I'm a bit of a techie, and that may come through in some of the things I say today. The UKJT is currently preparing a legal statement on liabilities for harms caused by AI. And I should say that I take my role as head of civil justice very seriously, and I aim either personally or via my civil leadership team, which includes Colin, to visit all or most of the 140 civil courts in England and Wales every 2 years. But I have a day job in the Court of Appeal. It might be helpful if I made clear at the outset that senior judges are not responsible for running the court service. That's the responsibility of HMCTS. HMCTS, from whom I know you've heard, is organised according to a framework document of July 2014 that provides for a partnership between the Lord Chancellor and the Lady Chief Justice in relation to HMCTS's effective governance, financing and operation. And the framework states that the aim of HMCTS should be to run an efficient and effective courts and tribunals service which enables the rule of law to be upheld and to provide justice for all, access to justice for all. Very important aims. And if I have three priorities, finally, in relation to civil justice, just to lay my cards on the table at the outset, they are first to ensure that paper is removed from the county court as soon as possible, as it has been in family, so that we can provide accessible digital court-based dispute resolution for citizens and businesses, for those are who we serve. And the second aim is to create an integrated pre-court digital justice system that makes maximum use of the existing public and private dispute resolution and advice portals to allow for widespread pre-court, speedy, effective and economical dispute resolution for those same citizens and businesses. And thirdly and finally, that there is a better understanding across government of the huge value of accessible dispute resolution, both to the economy of England and Wales and to the well-being of the same citizens and businesses that I've referred to now 3 times. Justice really should be front and centre in government. And I'll hand over to Colin.
Well, thank you, MR. I've been Deputy Head of Civil Justice since January 2021, when I joined the Court of Appeal. I started my full-time judicial career in the County Court in 2010 as a specialist circuit judge. I helped set up the Intellectual Property Enterprise Court, which is a forum for small and medium-sized enterprises to bring and defend intellectual property claims. I moved to the High Court in 2010. I had responsibility for the business and property courts in Wales, the West and the Midlands from 2017 to 2019, and then I became judge in charge of the Patents Court. I started attending the Judicial Executive Board last year. As Deputy Head of Civil Justice, I'm the Vice Chair of the Civil Procedure Rules Committee and the Civil Justice Council that you've heard the Master Rolls mention already. In fact, I joined the Rule Committee in 2014, and as the MR mentioned, in practical terms, my role really is to be the day-to-day chair of that committee. Since 2016, in the international positions, I've served as an international judicial member of the Boards of Appeal of the European Patent Office, and since 2023, I've chaired the Judicial Advisory Group on Artificial Intelligence here. The role of Deputy Head of Civil Justice involves a specific focus on the County Court. This involves visiting courts, as the Master Rolls has mentioned, but also working with the presiding judges, who are the judicial leaders on the circuits, and the designated civil judges, who are the local leaders of the County Court. I also run the Civil Executive Team and sit on a number of other committees to work closely with judges and with HMCTS to help run civil justice. As DHCJ, I see my role in particular as to make every effort to listen to our excellent judges and the staff and to support them in the hard work which they do. In terms of priorities, I support what the MR has said wholeheartedly. The work of the County Court is of real importance to the economy and to the well-being of particularly of vulnerable people. We do need to ensure that paper is removed from the County Court to make our courts as efficient and effective as possible. A pre-action digital justice system, is within reach, not as a monolithic system, but by the imaginative use of rules and data standards to allow existing providers to integrate the provision which already exists. Thank you.
Thank you very much for both our witnesses. We are, as I say, we're going to we're going on in due course to talk about some of the issues you raised around ADR mediation, around AI, and also some of the progress that's been made, for example, under the reform programme. But I think it's only right we start with just a few questions about what our own experience from the evidence we've taken and the visits we've undertaken, and also the evidence which has been coming in response. Perhaps the easiest way to do that is for me perhaps just to read I think a fairly typical submission that we've had, or a few sentences from it, to give an idea about what some court users think about the county court at the moment. It's from a very long-standing housing practitioner of over 30 years, over 10,000 cases under her belt. There's very little research on the county court. Cases are not reported, and there's a lack of usable data on a range of important issues, including attendance, representation, and outcomes. The county court has poor management systems and block listing of cases, which is predicated on most defendants not attending their hearing. Between 2010 and 2018, the government embarked on a reform programme which resulted in almost half the courts in England and Wales being closed. Courts are now located further apart and often combined, creating huge criminal and civil justice centres. Cuts to the justice budget resulted in the closure of court information counters, reduced administrative staffing and judicial sitting hours. The buildings that remain after the court reform programme are often poorly resourced and dilapidated. The evisceration of legal aid, with the enactment of the Legal Aid Sentencing and Punishment Offenders Act, means people now struggle to find representation. I think that's a pretty typical response. We've received a lot more trenchant than that as well. And if you were a user of a lot of services and you were getting reviews like that online, you'd be concerned. Do you recognise that picture? And what's your route away from that, insofar as it is accurate?
Well, of course, I recognise all of that. We get it in different ways from different people some of the time. I do not think it's entirely fair. I don't actually think it's entirely accurate either. And I think it takes no account of the depredations of COVID and the strenuous work that has been done by judges and also by HMCTS and MOJ to recover from COVID. So probably no profit in saying how we recovered out of COVID or didn't recover quite completely. I think more importantly than that, it really isn't fair to say that the county court is a terrible place where you get no response and nothing is dealt with efficiently, because that isn't correct. There are parts of the county court where things are slow, inefficient, and in some cases it's true that people are, well, it is true that there is less legal aid available in civil justice now almost than ever before. And that is as much a problem for judges, who have to deal with much larger numbers of litigants in person than they did in previous times. And that creates a problem for the efficiency of the court. But that piece that you read actually raises almost every problem the county courts have. It raises the problem of buildings, of staff, of the accessibility of the courts themselves, delays, almost everything we could talk about for the whole afternoon. What I would say is that we are moving away from that. Actually, in most parts of the country, the county courts are running efficiently. I would say there are 3 hotspots of inefficiency, and we are addressing them, but I think they need further addressing. One of them is Northampton, which I know you, Chair, visited yesterday, the Civil National Business Centre. The second is the Central London County Court, which I know you visited a month or 2 ago, and certainly requires interventions. And the third is the problem of a lack of district judges, salaried district judges, in the south east of England and in London. But if we were to ignore all those and look at the position in the west of England, the north of England, the northeast of England, in Wales, we would find most courts, and I visit them everywhere, we would find most county courts delivering a reasonably good service. The problem are things like Northampton, which delays getting the cases to the county court. So when the county court gets a case a small claim, for example, it will list it in a matter of weeks. But if it doesn't come out of Northampton, as was historically the case, but is better now, historically they were sitting there for 6 months or more. Well, that's quite unacceptable. But it is being addressed, and it's very important that it is. And the solution to many of these problems is, in fact, taking the paper away and ceasing to move around files, which delays everything by weeks and weeks.
Thank you. Do you want to add anything?
Just one thing. I mean, I agree, of course, with what the Master Rolls said. I think a critical thing, which is what's been said, but if I can just emphasise it, is the diversity of the county court itself. It isn't the same. It is not a monolith, and there are problems in some places which aren't in others. And just taking the problem cases are the ones that Master Rolls identified. We're just putting some colour on it. The listing thing. If you have a case that comes out of Northampton, and it goes to a court outside of the southeast, it is listed pretty quickly as a small claim. But there's a huge difference, there's a big difference, maybe I shouldn't exaggerate, there's a big difference between the time you can list a case once it's come out outside the southeast and in the southeast and London. We can see that in the management information. And that's the part of the problem that the Master Rolls is talking about.
You mentioned small claims get listed pretty quickly. What about bigger ones?
Well, perhaps I can deal with that. Small claims are generally dealt with quicker now than they were last year. So the average time to a hearing is 50 weeks, whereas it was 55, I think, or 54 a year ago. Big claims take longer, but you need to understand about civil justice that the speed at which civil justice goes, particularly with big claims, is nearly always determined by the parties. The parties are often not ready for cases to be heard, and so you can't really judge how efficient justice is by the bald statement of the number of weeks of the average from start to finish. 90% of civil claims settle before they get anywhere near a judge. And so you can look at the 77 weeks, I think it is, from beginning to end for a multi-track case, but that doesn't tell you that there were 9 other cases which settled satisfactorily before that. And so the data that is kept is generally inadequate. And there's 2 or 3 reasons for that, but one of them is that it takes no account of the type of case. And it's really, really important to understand, as I gave you in my evidence, the very, very diverse range of cases the county court deals with.
Yes, and indeed, in your evidence, you said it was a patchy picture.
Yes.
We did, as you say, go to Northampton, both to the business centre and to the county court yesterday, and to central London. And it's right to say that I think one or two of my colleagues used the phrase Dunkirk spirit to describe the staff at both, in a complimentary way, that they were coping with difficult circumstances in a fairly heroic manner. Paper certainly was the predominant material that we saw. And as far as, we'll come back onto this perhaps when we talk about the reform programme in a moment, but yes, they may be some of the more difficult nuts to crack at the moment, but what would you say to the fact that much of the systems there are still paper-based at the moment, or go from digital to paper in the process?
I think it's a terrible shame. I think the reform programme, I was in on the ground floor of the reform programme. I was just becoming Chancellor when it was initiated, and I vividly remember a meeting of the Judges' Council where the head of HMCTS, I can't remember who was chair or chief exec, it doesn't matter, said in the end of the reform programme, I think it was 4 years, every judge will open their computer in the morning, it'll say, "Good morning, Judge," and the papers for the day will be on your computer. Now, in family and in other parts of the system, that, to a large extent, happens now. Unfortunately, in civil, it hasn't happened. I think the reason, partly, is because of the large variety of cases and the fact that it has proved ambitious to digitise everything with multi-parties, different types of cases with different requirements. In fact, I think that problem can be overcome. And I'm very disappointed that we're going to reach the end of reform with only 23% of cases beginning and ending with digital, and all the rest ending up on paper. And the worst of that is that we have overlapping systems. So every case in the county court, or nearly every case, will have some paper, will have some digital, or will have been on digital on the modern system, and will also be recorded on what is called Caseman, which is a legacy system, very, very old-fashioned, been there for donkey's years, literally, and it simply can't interact with the other digital system. And in fact, there's a fourth, because people are so frustrated in the county courts. These fantastic staff that you talked about, Chair, which I must say I would reiterate are truly heroic in many, many cases. Many of the HMCTS staff have been in the same court for 30 years, and they have battled through thick and thin to make the system work, and they're deserving of great commendation. But they're fed up with the paper, and they digitise locally on a fourth system, which is simply a PDF file that they've scanned some documents into the system. But of course, that doesn't communicate with the digital system, that doesn't communicate with Caseman, and you've got to have some paper. I mean, to give you an example, one of the worst iniquities, which I highlighted, I go on a tour of about 20 courts every September, is that the new digital system had no means by which the correspondence could be uploaded. And when the judge looks at a case for trial, the first thing the judge wants to know is, has the case settled? And the correspondence tells you that and nothing else. So the judge has to ring up the office and say, is there a letter somewhere in the office saying the case is settled? Because otherwise I'll be reading the case and there'll be no need to have done so. So there's, the answer is we're in a terrible twilight situation, and we must do better in the next 4 years through the instrumentation of the spending review that's coming up.
Thank you. You were talking about the array of cases, and you said, I think in your evidence you gave us a list of non-exhaustive list of, as you described, of 37 most common types of dispute resolved in the county court. And I just wondered, could I ask you to consider whether the role of the county court within the civil justice system should have been reformed before anyone attempted to digitise all of the work that's attached to it?
Funnily enough, I don't think so. The county court deals with every civil dispute quite properly that citizens and small businesses need to have resolved. Much of the jurisdiction is provided by new statutes, so antisocial behaviour orders, non-molestation orders are examples, and they've of course become extremely prevalent due to the societal problems that we face. So I don't think you could have a wholesale reform that would change that range, that spectrum of cases. There is a problem which you may be alluding to, which is the intersection between the county court and the high court, and that has been problematic for a very long time. We thought when reform started, and I'm sorry, shut me up if I'm trespassing on reform before you want me to, but we thought when reform started that we were going to have one system, one digital system across the entirety of the courts and tribunals, which was going to be what we call CCD, which stands for Core Case Data, which is what we call now the basic county court digital system, which already covers all the family cases, some of the civil cases, and some of the tribunal cases. And you've seen that in the letter that Nick Goodwin wrote to you from HMCTS a couple of days ago. Unfortunately, when they introduced CCD, it was very ambitious to cover every kind of case, however complicated, and it's not proven easy to extend it to complex cases, particularly with multi-parties. It's not certain it won't be possible. It may be possible. We'll have to see. But certainly in the 4 or 5 years that was expected, it's not been possible to extend it to everything. So at the moment, we've got these multiple digital systems. We've got something called CE file in the High Court, which is a fairly basic data filing system. In the High Court, the Business and Property Courts, we call it 12 jurisdictions.
Everyone spoke highly of that to us.
Well, it's great, but it's simple and it's not fit for the future. And it doesn't produce any machine-readable documentation, so it's not a smart system, it's not a modern system, but it's incredibly serviceable, as I said in my evidence. So we've got that at the top dealing with the complicated cases, but its life expires in 3 to 4 years. It'll have to be replaced. We thought it was going to be replaced by the CCD system coming up from the County Court, but that looks less likely now. And so we're going to have the intersection that you were alluding to, I think, between the complex and the simple. And that's a shame, because we hoped one size would fit all. And the problem with civil litigation is it is very disparate. It ranges from a case in the High Court that may go on for 3 months and be worth billions of pounds to a case in the County Court that takes 10 minutes for possession of a home. And both are very important and require justice, and they have parties who really care. And if there be any doubt, we, as judges, really care about the outcomes in every type of case.
Thank you.
I'm just wondering whether we continue the reform discussion since we're on that vein and then move to the other areas.
We can do, if colleagues are happy with that.
Don't mind.
You just seem to follow on from what you were saying there, Sir Geoffrey. So this is the HMCTS reform programme. I understand it's cost £1 billion, and sounds like it's not delivered anywhere near the kind of change everyone was hoping. How do we get a grip of it, would you say?
Okay, well, I'm talking about civil. I think there are different issues in crime, and there are different issues in family, and I wouldn't want anything I said to be taken as applying to those, although civil, family and tribunals are connected because reform built a platform called the CFT platform, Civil, Family and Tribunals platform, and that is what was the main outcome for those jurisdictions. Now, how do we get a grip of it? The answer is family, which I'm not talking about, seems to largely be conducted in a digital system at the moment. It's got problems, I know, but you'll hear about that. Well, you may not, but there are problems, but it's not insuperable probably, or it may not be. Tribunals, some of the tribunals have been digitised, some not, and that job needs to be completed. So let's come to what I really know about, which is civil. We are in a position where half the job has been done, and it's not sustainable for all sorts of reasons to do half a job, because you've got these multiple data sources that simply don't speak to one another. So we absolutely have to complete reform, first of all, which is what was intended to be done, but even that wasn't everything. So, I vividly remember 4 years ago when I became, 4.5 years ago, when I was appointed as Master of the Rolls, being shown a document that said reform will deal with every case in the County Court except Appendix B, I think it was called. And that was a whole host of cases, like insolvency cases, like boundary disputes, like Tolata cases, Part 8 cases, which are sale of property cases. And I said, why are you not digitising those? And they said, oh, well, it's out of scope. And as the reform programme continued in civil, they took more and more things out of scope, and thereby really hollowing out the facility of what it was doing. What is my solution? Because there obviously isn't enough money to carry on throwing endless money at the same thing. First of all, I think it's this. I think they should rescope, which is really not all that much money, doing what they took out very recently. So they should rescope enforcement. They should rescope bulk claims, which is 900,000 claims a year brought in the county court mainly by utilities and big companies, which are on a legacy system called Money Claims Online, which is totally outdated. And right at the beginning, 4.5 years ago, I was told they were going to move those into OCMC, Online Civil Money Claims, but they de-scoped it at the last minute. They should re-scope that. It's not a costly exercise, needs to be done. We would then have most claims in the county court, except the tricky ones, started digitally and proceeding digitally. So when they complete what I think is imperative to complete what they were going to do in civil in reform, they then have to find the solution to how you're going to digitise complex county court claims. Some are. You take boundary disputes, that's a good example. They take 2 or 3 days, they're very complicated, sometimes they have multiple parties, and you have to find a way of digitising that. My solution would be to use the same solution as they're going to use in the High Court to replace CE file. That's what I think they should do. I think it's obvious. And to draw a line, a very clear line, between what you're using CCD for and what you're using CE file for. So you'll still have two systems, but everything will be digital.
Thank you. I think as a new member of this committee, I find it quite frustrating to hear all of that. I'm not a lawyer, and I'm sure the public would also, and the use of the court, all the professionals involved find this incredibly frustrating. I mean, you're both leaders in this aspect of the judicial field. How are you contributing to this? This urgent need for rescoping bulk claims and enforcement?
Well, we're at the moment contributing urgently in the MOJ's bids to Treasury in SR2, because it's all dependent on money. And I can tell you, we talk of little else, but how we're going to progress and make sure that we deliver a proper service in every kind of case to the public. But let me tell you, we won't be able to do that whilst 5 floors of paper continue to be hoarded. I'm not being rude about it, because it's not nobody's fault, but while you've got a paper system, you have a big, almost paper warehouse in Northampton, and we have to stop that, put it online. It saves, every time you put a case online instead of into Northampton when it's issued, it saves weeks, and I can't give you the number, 10 weeks for the parties in getting that case resolved.
I suppose the issue that you mentioned the figure, Master Rolls, of 23% for the success, put it that way, of reform. I think the original target was over 80%.
Yes.
And the evidence we heard from the Chief Exec of HMCTS a couple of weeks ago was that it would achieve, in its revised form, 61%. So we're a little at sea there. We're not asking you to account for other people's figures, but where did your own figure come from?
Let me just explain that 61%. Yeah. 61% is done on the basis of is calculated on the basis of the number of tasks that a judge undertakes. But a task for the purpose of the 61% could be a 2-minute application dealt with on the screen, or a 3-day trial. So they're not the same, and you can't say that 61% of judicial work is digitised by giving 1 point to a 3-day boundary dispute and 1 point to a 2-minute application online. So unfortunately, the 61% doesn't really mean anything. What does mean something is this: 23% will be the number of cases on completion of current reform that will be digital end-to-end, or can be digital end-to-end. We will then add to that possession and property claims that are being digitised with money provided by MCHLG, which is about 8 to 9% of county court claims, possession claims, about 120,000 claims a year. So that brings you up to about 31%. And then if you were to put bulk claims, that's the 900,000 that go through MCOL, into the digital system, which is what was proposed, you would come up to the 80 or 90% level. But you would still be not making judges use digital 80 or 90% of the time, because those bulk claims very rarely go to judges. They're normally the subject of default judgments. So, unfortunately, the ones judges see are that stubborn 10% that are the more complex claims, and you'll only get paper out of the county court and out of the judge's inbox when you find a way of digitising those.
Can I just add a couple of points of detail? First of all, the Master Rolls was talking about completion. What the date is September of this year. That's when the 23% becomes true. The second one, the critical thing, which took me a long time to get my head around as well, is you have to work out what number we're talking about. If you're counting issued claims, then you're including this million number of claims that are issued in the bulk system, most of which go nowhere near a court. So when you hear numbers like 80 or 90%, that's the denominator, if you like, is issued claims, total issued claims. The claims that get into a judge, or for that matter staff in our local courts, are mostly not those bulk claims. And that's why as soon as you start having numbers when you're looking at what's going on in the courts, the numbers start dropping, because the claims the judges are dealing with are much, much not those bulk claims, and the proportion which is digital is much smaller. And the other thing I want to just pick up, if I may, just something that Tessa Munt MP mentioned a minute ago, this thing about complexity. It is important to understand that complex claims are still appropriate in the county court. They're not complex because they shouldn't be county court claims. They're just complex from the point of view of our rather simple IT system that can't cope with them.
Maybe multi-party.
Thank you.
Yeah.
Yes. Thank you very much.
I mean, multi-party doesn't of itself sound terribly complex to me. To be honest, I'm quite staggered. Like the idea that judges habitually can't see emails between the parties, and this cost £1 billion. Sorry, £1.5 billion. Like the idea that I could go back to my constituents and explain that to them.
They can in family.
In terms of how that sort of pans out for litigants, sorry, I'm just so staggered. How did that come about? Like, how do you have an IT system that's set up with cases where the judges can't see the emails? Like, what was the commissioning process? How did we come to be in this position?
You've done it.
I don't know whether Colin wants to answer. I can perhaps help, but I think your view may be more accurate.
Well, I can say that first of all, I think it would be. I don't want to get the impression the judges can't see the emails. Of course they can. The staff can show them to them. What doesn't happen is that they're not part of the IT system, and that's very significant. I mean, it is very, very significant. I'm not trying to underplay its significance, but I don't want you to get the impression that they just can't be seen at all. That's certainly not right. But of course, what you want is everything to be there, and the approach has been to make the way the civil system was set up was to try and make it to take the easiest cases. That's how the whole project was run. It was taking the simplest cases to digitise and do that, and that's where we've come from. To be fair, right now the system does allow a fair bit of correspondence on the actual digital file. It just doesn't include email, but it doesn't. So there are some documents now on the digital file that will be coming out in September. But
the answer. Can I just try and answer your question? About how it came about. The judges, I mean, I'm not here to try and exempt myself from blame. The judges could not possibly design a system of this complexity. What happened was it was designed by coders, and they they probably took a sensible decision for the kind of common or garden case that is most of the cases. The small claims, the bulk claims when they come in, the personal injury claims that are just a road traffic accident between A and B. And they thought, well, we'll start with that. The other thing they did, which has proved to be problematic, it's not fatal, but it's problematic, is the whole system operates on a case status basis. And that means that every case has a status. It is at the stage of claim. It is at the stage of defence. It's at the stage of disclosure or whatever else is going to happen during the case. But it can only have one status. Now, if you've got two parties, you may have one defendant against whom judgment has been given, so that's the status for that defendant, and for the other defendant it's at another stage. And the system struggles with that. And that's why it can't deal very easily either with multi-parties or with high complexity. But I can see how it happened. I didn't do it. I can see how it happened because it was trying to crack the biggest nut first and assuming that technically it would be possible to crack the smaller nuts by additional devices. And by the way, that may well be possible in the future, but we've had to focus on getting the existing simplified system working properly, and that's what they've been doing. And it does work very well. I mean, I don't want anybody to go away with the idea that this is an absolutely terrible system. It's a good system, and the users are very pleased with it.
You say that if I may, picking up on something that the Marshal just said, the other answer to your question is that the focus at the beginning was on litigants. Mm-hmm. And it's really hard to say that's a bad idea. I think, to be fair, that was a really good idea. And so they worked, HMCTS with the Judiciary worked extremely hard on the interface, that is the user interface between the litigants in person dealing with the system and the system itself. And one of the ways in which we know that's paid dividends is that the response rate for defendants in the reformed digital systems compared to the old-fashioned systems we have is much, much, much higher. It's quite astonishing, actually. And it shows you that it's an extremely well-designed system from the point of view of litigants in person to get them to engage, because one of the hardest things in civil justice is getting people to engage. We don't want them to not engage. And so things like the level of default judgments is much, much lower in the online civil money claims system than it is in our bulk MCOL system. And that's because, actually, the focus was on that. That was what everyone was looking at. I mean, I think that's actually one of the main reasons. But the state, the thing the Master Rolls mentioned about this case state, that's actually part of it too.
Thank you.
Thank you. Nonetheless, the money has been spent that was there, I think all but a very small proportion of it. There doesn't appear to be a lot of resource available now to continue. Have I understood correctly, Geoffrey, that you're saying that you believe there is merit in pursuing the reform programme, notwithstanding the fact that it's only been partially successful?
It doesn't matter what you call it. I think everybody's very keen to stop the reform programme dead in its tracks at the 31st of March. Yeah. That's fine. I think it's very important that the work that was within scope previously of civil reform should be completed, and that wouldn't be hugely expensive. It doesn't matter what you call it or as part of what programme it is. No, it has not been unsuccessful. What has, I think, been underestimated, I would say, is the problems that would be thrown up by the complexities of the number of different kinds of case you have in civil. And every other part of the system has not had that problem. So employment tribunals, they have a system that works very well because all the cases are between an employer and an employee, so it's fairly straightforward. The same in the Social Security Tribunal and so on. But in civil, you may have endless different permutations and combinations, and that's what's thrown up the problem. I think the problem can be solved fairly easily and with not vast amounts of money. I mean, we talk to HMCTS, Colin and I, all the time, and we don't get involved in the figures because we can't. It's up to them to decide if they've got the money. But the figures we're talking for various bits of de-scoping are small, I mean, in the context of what we're talking.
Thank you. We have the Minister coming to see us in a couple of weeks, and we can perhaps take that a bit further with her.
Well, it is small. I mean, the millions, but it's not hundreds of millions.
I mean, maybe, if I may, just one, just picking up on what the Master Role said, which I, of course, agree with. What's needed to finish it is a simple system for complex cases. Where what didn't happen, because it turned out not to be possible, was to build a complex system to deal with the complexity of complex cases. It's not sensible. But if we build a really simple system, we can accommodate all the complex cases. That's what needs to be done.
And one other thing that's worth mentioning, which it would be great to propagate around the place. This is a digital system where you go online and it says, what's your name, what's your claim, where do you live, have you got a solicitor, blah, blah, blah. If it only had and the main program is called Damages Online, because it's created for people who want to claim damages, mostly in personal injury cases. But if it had another page that said, do you want to have anything else, any other kind of relief, it could then cover injunctions, declarations, orders for sale, other kinds of case. And that would bring into the digital environment a lot of cases. Now, they didn't want to do that originally because the information put on a text document would not be machine readable and would not be smart in the way that the rest of the system is. But if we haven't got any money, that should be a relatively economical way of doing a large amount of what needs doing.
Anybody else want to come in on reform before we leave it?
Just very quickly, Sir Geoffrey, you mentioned employment tribunal claims. You can get multi-party claims in ET claims as well. So have you had similar difficulties when there have been multi-party ET claims?
I'm not familiar with the employment tribunal digitisation, but it's on the same platform and it's built in the same way. So I'm sure that anything more than two parties on one side will create the same problems there. I say I'm sure, I think.
I mean, just to explain, the problem is it's possible to cater for that, but the resource cost of doing it multiplies as you make it more and more, as you add more people. That's the difficulty. So I can't tell you what happens in the employment tribunal, but as soon as you deal with two people, you have to have a whole lot of extra stuff, and then three, a whole lot more. Do you see what I mean? That's the difficulty. It can be done, but it just ends up adding enormous complexity to do it.
Can we just go back to staffing issues and judicial capacity? Lindsay?
Yes, thank you. My children will attest that digitalisation is not my forte, so I'd like to talk about the human side of the court system. And we're starting with judicial capacity, really. The recent Judicial Attitudes Survey, produced by the University College in London, concluded that the judiciary was facing, and I quote, looming retention and recruitment crisis, which is sounds very worrying to me. So could you explain what's driving that, if indeed it is correct, what they're saying?
Well, I think it's only partly correct, actually. There is always, or not always, but in my judicial career, which now spans, 16 years, there's always been some recruitment problems at different levels. So we went through a period in the last decade where the pensions were changed and senior judges were not attracted to the judiciary. So there was a recruitment problem in the High Court. That was resolved about 4 years ago, and now we seem to have far less problem recruiting High Court judges than we did. There are problems recruiting circuit judges, probably to a lesser extent than the problems recruiting district judges, but the main problem is recruiting district judges to serve in London and the South East. And I suppose we could all use our own insights to say why that might be. London is expensive to live. The people taking the jobs are not, perhaps, they're probably 40 and over in most cases, and therefore they're looking perhaps for more pleasant places to live. They may have worked in London and lived in an expensive place for some time, and parts of the southeast are more deprived than other parts of the UK. There are all sorts of possible reasons, we don't know. There is a competition going on to recruit district judges only in the southeast and London, and I believe they've had a fairly healthy number of applications. So we'll have to see what happens at the end of the year when they reveal how many they've been able to appoint. It is a problem, but I don't believe one should exaggerate it. I think maybe it's slightly... you have to understand what you're talking about. Being a district judge is a great job. Our district judges do a fantastic job. The reason why they do is because they do such a wide variety of work. So they do family and they do civil. And that is, a pretty tall order. You have to know 2 whole areas of expertise. They've got to be able to tackle all those 38 kinds of case that I mentioned in civil, and they've got to be able to do financial remedies in family, they've got to be able to do care work, they've got to be able to do private law, family work. It's a big range. And some solicitors and barristers just don't want to do that as they get older. So we have to make it as attractive as we can. There have been all sorts of other issues that you've covered in some of the questions you've posed, like the working environment. They've had a lot of leaks in the roof of the buildings, but HMCTS is really tackling that now, and I believe the programme for repairs is well advanced. But that doesn't make life very easy for judges. So I don't think it's monodimensional. I think you have to look at the whole of the Judicial Attitude Survey. I can say this, I started the Judicial Attitude Survey back in 2014, and I've been working with UCL, Professor Cheryl Thomas, for all those years in putting it together, and we now ask lots and lots of questions we would never have dared ask back in 2014. And the information, we get 99 or 98% of judges, salaried judges, responding. So we know exactly what everybody thinks. And I think you have to really look quite deeply at it to work out what they're unhappy about and what they're happy about. Judges really still love their jobs, almost universally, because it's a very rewarding contribution to society.
Thank you. You've mentioned the issue in London and the South East in terms of recruitment, and I know you've said that there's the application process at the moment, but I think in evidence previously you've said that because of that problem in recruiting in those areas, there's been an over-reliance on fee-paid deputy judges. Yeah. Is that still the case until this is resolved? And if so, what problems does that bring to those areas?
It is really a problem. Civil has always been the jurisdiction which has over-relied on fee-paid judges. And that is mostly because family cases require a salaried judge who's there and can adjourn the case till 2 weeks' time and will be there again in 2 weeks' time. Whereas civil cases, generally small claims, you can take a list of small claims and they'll all be finished that day, and it doesn't matter if you're going to be there in 2 weeks' time. So we've always in civil relied, as many as 50% of civil cases in the county court historically have been heard by fee-paid judges. Now, don't get me wrong, fee-paid judges are great. They are extremely able, they're extremely committed, and some of them want to become salaried judges. But we would prefer, and when I say we the senior judiciary, it sort of sounds very grand, it's not intended to, would prefer that the fee-paid judiciary was there for really 2 reasons. One, where we have a problem, like we've got in London and the South East with district judges at the moment, and 2, as a channel to entry to the salaried judiciary. But unfortunately, people in the legal profession find it attractive to have a bit of variation in their middle years, and they enjoy sitting as a judge for 30 days, sometimes 60 days a year, and carrying on with their career. And so not everybody, as we see from the Judicial Attitude Survey, not everybody comes into the fee-paid judiciary and then moves through to the salaried judiciary. That's a problem. We're trying to deal with it. We're trying to make it a little bit less attractive in the sense that you can no longer sit 180 days as a fee-paid judge, which you used to be able to do. But on the other hand, we need them when we need them. Second part of your question, sorry to be long-winded about it, the second part of your question is what's the problems that it causes? Well, fee-paid judges who don't sit every day tend to be a bit slower. This is not a criticism. They're making sure they're doing the job right, but they don't have the vast experience that district judges who've been there 20 years do. So they don't do things quite as quickly. They don't do as much box work because they sort of come in, read the papers for the day, hear the cases and go home. If the case goes short, they'll do box work, but sometimes it's not available, or the IT isn't in the right form for their computer, or there isn't a borrowed computer available. So there are problems of that kind. And basically it creates, I would say, a less smooth disposition of justice, where you don't have enough salaried judges. I mean, actually, salaried judges in a court make it run smoothly. The relationship, I should say this, the relationship between judges in courts and their staff is almost universally. I can give you 2 examples where it's not the case, but of the 140 courts is absolutely incredible. They are so loyal, the one to the other, and that makes the system work. So if you're salaried, that works, but if you haven't got any salaried judges, it makes it problematic.
Yeah. Just if I may just add one more thing, to answer your question directly. One of the things which, when you have a good relationship, as we really do a lot, between the listing staff and the salaried judges, the listing staff know who they can give things to, and you can, as an experienced listing officer, you have a cadre of salaried judges, and you can just be more efficient because you know who you're dealing with, and you get to know your fee-paid judges too. That's also true. I don't want you to think that's not true, but it isn't the same, and that's just one other dimension to this issue. And so we are over-reliant on fee-paid judges, and until we can recruit enough DJs in London and the South East, that's going to be a problem.
And we've got the virtual pilot, which provides 2,000 or 3,000 days a year with judges sitting from the north and the northeast and the west and other places to try and clear backlogs in London, and they sit remotely, and that's been very successful actually.
Thank you. And that's really interesting. Thank you. And my optimistic nature is hopeful from what you've just said in going forward. What would the appropriate balance be? What would you like to see between salaried judges and fee-paid judges?
Yeah, we've always said 80-20.
And what is it at the moment?
80% salaried and 12. In family, it's 80% salaried and 20% fee-paid. In civil, it's 60-40 or 63-37. I don't know the exact figures. I would much prefer to see 80-20.
Across the board.
Yeah.
Thank you. And you've mentioned the recruitment process, the recruitment campaign that you have running at the moment, and applications are starting to come in, and you'll know more by the end of the year. Are you optimistic? Do you think that that's going to reap some benefits and rewards?
Yes,
going
I'm
forward?
cautiously optimistic. Last year, we did a competition nationwide for 100 district judges and only got 50, I think. Yeah. This is a competition for 80 district judges, but limited to London and the South East. And one of the problems has been that when you advertise for district judges, people don't really want to move they have children, they have families, they have commitments and so on. People don't really want to move when they become a judge. And what was happening was they would advertise a particular circuit. And the southeastern circuit comprises places as far apart as Ipswich and Brighton. And so you would apply, if you lived in Brighton, to become a district judge on the southeastern circuit, and they'd offer you Ipswich. Well, Ipswich is not really in the southeast, in the same part of the world as Brighton. You certainly can't commute. And so that was causing problems, and now we're trying, or not me, but the JAC is trying to be clear about where the vacancies are, so that you can apply if you live in Brighton, knowing that there will be vacancies in Brighton or Hove or Worthing or somewhere relatively close.
Can I just, one thing you ought to be aware of is that this 80 number, that's the vacancy request. It's important to understand that that's not the same as the business need, because the vacancy requests also take into account the capacity of the recruitment exercise. There's no point in having a vacancy request of 200 and then resourcing a recruitment exercise for 200 when you know you're never going to get more than, for the sake of argument, 80 people. So one needs to be a little bit careful with what these numbers are. We actually need more judges than that, but we know we're not going to be able to recruit more. So that's a factor that goes into these vacancy request numbers. You just need to be aware of that.
Yes.
Practical question. And speaking as an Eastern MP, how difficult would it be to separate those circuits, have a Southern circuit and an Eastern circuit?
London and the South East.
It's not really a question of separating the circuit. It's really a question of saying I've got a vacancy in Brighton. That doesn't sound too complex to me, but for some reason it has proved a little more complex than you might think, but we're doing it better now.
I mean, it's fair to say we've been wanting to do something like this for quite a long time, because I suspect it seems blindingly obvious, if I may say so to you, that we should be trying to do something like this. There's lots of problematic bits, but we're now doing it, and it's really worthwhile.
And I'm optimistic with Lindsay.
I am too.
Can I bring
thank you for that, Sir Geoffrey. So the recruitment crisis is with salaried district judges in London and the South East. Somebody like me who lives in Wolverhampton, it could be quite possible, couldn't it, for me to apply for a district judge's job in London, because travelling isn't that bad. Would you agree with that? And the other question I have is that is there anything proactive done to encourage more solicitors and barristers to become salaried district judges in London and South East?
Yes. I sort of don't agree that it's necessarily easy to travel from Wolverhampton to London, because the train fare's so expensive, as I think you may have noticed. But district judges don't really want to live in Wolverhampton and work in London. I mean, history has shown that to be the case. They want to be able to travel a few, maybe 20 miles, but not 120 miles. Yes, a lot is being done to encourage and recruit in all sorts of ways. It's tricky, but the main route is to encourage our cadre of 800 deputy district judges, who are themselves fantastic, to apply for the full-time job. And I mean, I personally go to every I or Colin or one of our civil leadership group, often me, go to every continuation course, and I speak to 60 or 80 mostly deputy district judges, and the whole purpose of that is to make them love us, to make them want to become full-time district judges. And it's getting more successful, but it makes a lot of excursions for me.
On the recruitment that you talked about, do you think that the practice of having judges cover such a wide scope of activity reflects quite an outdated idea about how solicitors in particular come up through? So you wouldn't now find a solicitor who is jack of all trades in that way, and then they can't get through the judicial assessments because they don't have the skills to. Do you think that you are unduly limiting your potential pool of applicants by making the requirements so incredibly broad?
Well, I doubt actually that is causing people who have got the right skills to be appointed. And the reason I say that is because we are absolutely seeing exactly what you're talking about. Because what's happening now is that the new cadre of deputy district judges, which both, if I may say, the Master of Rolls and I go and talk to on a fairly regular basis, are not as familiar with large areas of civil and family justice as if you'd imagine a situation 20 years ago. And it's not just solicitors, that's the bar just as much. The world is much more specialised now than it used to be. And what's been happening, and I think it's a good news story, if I can put it this way, what we've realised, and this is the Judicial College and the work that we're supporting them in, and which they do a fantastic job, and the judges who help the Judicial College and run those courses also do an incredible job, is we've realised this, and so we're now working on ideas for dealing with the fact that the judges who are coming in, the new judges, don't have that kind of experience, and they need more training, they need to be helped to be able to do that diversity of work. It's really important, but that's what we're doing.
But one of the functions of having a local court where you can go and have your case tried locally is that the judge can deal with a fairly wide range of stuff. And if they couldn't, then you'd be pushing them off to Manchester or to Birmingham or to London to find a specialist judge. Yeah. So I think it is desirable. This is not unlearnable. It's a bit of a challenge for a solicitor who's done takeovers to become a district judge doing, family cases and doing cases for possession of property. But it's not impossible.
No, not at all.
Just to pick up on what you said, I've just gently challenged that. I live in Somerset. If I want to access specialist health facilities, for example, I have to travel, generally to Bristol, sometimes to Birmingham, depending on what sort of specialism I'm looking for. And because that's where the specialists are, and certainly having worked within legal firms, I recognise that some of the work that I did for the legal firms for which I worked would only have been found in the cities, the big cities, perhaps 5 or 6 cities. And so anybody, wherever they lived, if they were out in the sticks, where I live, they would have to go to Bristol, to Leeds, to London, to Manchester, Birmingham. So I don't know that it's actually so peculiar that one would recognise the need to travel some distance to find your specialism. The other thing I would say is that in an area where I have almost no public transport, those of us who do not have cars, if we wish to go to Taunton, which is my local court, you have to leave the day before and stay overnight if you wish to travel by public transport in order to be there for 10 o'clock in the morning. So I think probably the difficulties of either travelling to my local court is 25 miles away, or finding specialism, one would have to travel. I don't think anything of travelling 25 miles or indeed 50 or 100.
Well, it used to be said that there had to be a court within 1 day's ride on a horse.
And there
for every citizen.
Yeah, we don't even have horses, I'm afraid.
For every citizen in our country. But the reason I would push back in return is that the people that are involved in county court cases are often the most vulnerable in our society, who have the least money. Colin said earlier, we want them to engage with the case. We do not want justice done to them.
Indeed.
We want there to be justice for them. And to do that, they have to engage. And to do that, they have to be there. And if they have no money, and sending them to a big town is not really desirable. It is really, really important that we have local judges. Now, these cases are not hugely complicated. You can do a possession case as a lawyer, having done a few and observed a day in court, it provided you're the right standard of lawyer. So I personally think we should keep local courts to serve the public.
Thank you. So I just would say that our local courts are not terribly local for most of the impoverished population.
May I, sorry, forgive me. Can I just say
course.
one thing to answer your question? It actually ties in with the point before about salaried and fee-paid judges, because actually it's the salaried judges who get the experience that can deal with all the standard kinds of complex, middle complexity cases. They can do possession lists, they can do personal injury claims. That's what they do, and actually that's why there's such a value in having salaried judges, because the salaried district bench, actually they can handle that stuff. That's what they do, and they're good at it.
Can I ask you? Thank you very much. Thanks for your tolerance. I wondered if we could just. You were talking about the relationship between judges and their staff, and I wondered about the impact, perhaps, of staff who are agency or are just inexperienced, and maybe there's a relatively high turnover. What impact that has on the operations of court? And I know that this came up in the Judicial Attitude Survey in relation to concerns about staffing reductions. So might I ask you to comment on that?
Do you want to?
I mean, we have fewer agency staff now. Fewer.
Yes.
So I believe. I mean, that's really a question for HMCTS, but that's my understanding. Experienced staff are, of course, more valuable. And at a time when there were a lot of agency staff, I'm thinking of a few years ago, it was a problem. But when you go to a county court with experienced staff, you can tell the difference. So, of course, we want to have experienced staff, and we need to retain them. And one of the problems in our system, actually, is the retention of staff, because we often have a difficulty. I'm thinking of Cardiff as an example, where there are other bits of the public sector who will recruit people from inside the public sector, inside HMCTS, at a certain band, because the staff will go because they get paid more money for the same band. Indeed. In another part, and it's I will say a constant frustration for us in our system to see our good staff going to other parts of the public sector.
Yes, thank you. Can I also ask you about the block listing in certain courts as a way of addressing the backlogs, and what your views might be on that?
Right, block listing. So block listing is a fundamental part of the way our civil system works, and we do it carefully, and we try and do it right. The point is that because of the thing that the Master Rolls has mentioned already, many cases will ultimately not come to a final hearing, and that might happen the day before. It might happen on the morning of the final hearing. Sometimes it's because they settle, sometimes it's because sadly somebody doesn't attend the court, but there are all kinds of reasons for that. So in order to be efficient, the way in which all our courts work is that we will block list. In other words, for the sake of argument, you will have 2 district judges available on Thursday, and you will list 4 or 5 small claims. Probably, actually, if you've got 2 district judges on a Thursday in a middle-sized court, it's probably 4 or 6 small claims, maybe even 8. And that will, normally, that will be fine. And that's how it's done. And if we didn't do that, we'd have even longer delays. So block listing per se is not a bad thing. One of the things that we've done recently is we've had a civil listing project, which the civil executive team, which our chair has run, and led by a designated civil judge in Birmingham called Emma Kelly, Her Honour Judge Kelly, who's really been brilliant. And that listing project has tried to identify the best practice for block listing for different kinds of case. So it has details for things like for a big court, how many cases can you block list if they're small claims, how many possession cases of certain kinds, how much time do you give to them. And that's the way in which we have an efficient system. And the way judges who run block lists work is they know that they've got how many cases they have to deal with, they manage their list, and by and large it works very well. Now, of course, occasionally you have to cope for the possibility that more people attend than you were hoping for, and that's where the flexibility comes in, because if you can get it right, you have a judge somewhere else, you have another judge in the building, and by juggling and by good listing officers and experienced listing, most of the time block listing works. Now, I'm not going to pretend that there won't be times, because there will be, when of course, I mean, I'm going to say it as if it sounds odd. Unfortunately, too many people turn up. And I mean, I don't mean that really, but you understand what I'm trying to say.
Yes.
And then you have to find a way of dealing with it. And occasionally that's a problem. But it actually, to not do it would be far worse than to do it.
So we have had highlighted the matter of late adjournments.
Yeah.
And so what's the ideal time for someone to be informed of an adjournment?
Gosh, well, I mean, the ideal time would be as early as possible, but
yes.
we know in the real world, I mean, we know, for example, that in the reality in civil justice is that the court door is a place when many people settle. And actually, a physical courtroom is a great tool for settling. And that's the reality of the work we do, and we know that. And of course, it would be delightful if everyone could. And we've got compulsory mediation. Perhaps we'll talk about that later on. But we have ways of trying to do that. But that's the answer to your question.
Thank you very much.
Thank you.
Could I've moved on without taking questions?
No, it's fine.
Nancy. Are you sure?
Yeah.
Could I briefly return to digitalisation, because we believe that salvation that way may lie. Which I think Geoff, could you explain how your vision for the digital justice system has evolved from a single point of entry to a data standards approach?
Well, I think they're two different things, actually. The digital justice system is something that deals with the pre-court environment. So my 15 million cases, there are literally, almost half the adults in the country are involved in some kind of dispute often, and will have familiarity with some kind of dispute, whether it's family, a tribunal, or simply a gas bill, or something on eBay, or something on the internet. They will have had some kind of dispute. And my vision was that the online environment allows people to go online and to find the dispute resolution process that suits that, querying the gas bill, having an argument about a tenancy, having a housing dispute, etc., making a personal injury claim, without needing to go to court. And the idea that I expressed 5 years ago was of a funnel, where lots of people had a problem, they went online, they got directed to the right place to resolve the dispute, and the funnel got smaller until at the bottom of the funnel the cases were transmitted. The data concerning the dispute was transmitted by API, Application Programming Interface, into the court system for final resolution, but there would be 15 million at the top and 1 million at the bottom. All those would have been resolved satisfactorily very quickly by a system of signposting. Now, that has become a sort of reality. I'm not going to claim it's quite in place yet, but there are at least 100 portals that aim to resolve disputes or give people advice who are in dispute about getting a resolution. And the digital justice system is going to be organised, or rules are going to be made for it, by the Online Procedure Rule Committee, which is the committee I chair, and is empowered by Section 24 of the Judicial Review and Courts Act of 2022. And only yesterday, Chair, both Houses of Parliament passed a positive resolution endowing the Online Procedure Rules Committee with the power to make rules for property cases, which is fantastic. And that means that not only can we make rules that concern the court space, but we can also make rules that have some bearing on the pre-court space. Now, the data standards question is really, there are two things that limit the way people navigate the internet. The first is that they may go on a site and get dispute resolution, but then have the data untransferable to another site or to the court. So one of the rules that the Online Procedure Rules Committee is likely to make is to say you really have to adhere to these simple data standards, so that if you don't resolve the dispute in the Housing Ombudsman portal, you can send the data to court, say. The second thing that is a limiting factor is the absence of interconnections. So many people, ordinary people, often vulnerable people, they can go online. They're not digitally disadvantaged in that sense, but they don't know what their problem is and they don't know where to go. And the idea of the digital ecosystem is to make it a rule, effectively, that anybody who runs a site, like, for example, Advice Now, the Citizens Advice Bureau, or the Personal Injury Portal, or the Ombudsman for Financial Services, or for housing, or for retail, or for anything, if somebody comes to them and says, can you sort out my problem, instead of saying, no, we don't have the statutory power to do that, they say, we don't, but we suggest you go somewhere which will, and if not, if they don't know of the place to go, they will direct them to advice. And I think it would be marvellous if legal aid were provided in the digital environment, so that people could simply go online to a solicitor with or without the use of AI and get directed to the place to resolve their problem. Its diagnosis is a very large part of the cure. Once you know, I always give this example, that many people don't understand the law, they're completely ignorant of it, some of them regard that as a badge of office, and they may go online and say, I've got a bad foot. And when you actually interrogate, they've got a bad foot because the bailiff came and slammed the foot in the door and they got injured. But their problem is defending the possession claim and not being thrown out of their home, not their foot, which will heal over time. And the difficulty is that people need, this is a time of trouble for people, and people in time of trouble need help. And the digital environment is uniquely well placed to give them that help. So I'm an optimist, I've already said that, and it's true, and I think it's a long project, but we've got the Online Procedure Rules Committee. The objective must be to resolve all our millions of disputes quickly, economically, and efficiently, so that people can get back to work. And one of the things that I really do want to say is that there is a really poor understanding of the value of getting people's disputes resolved. When you go to work, you see people in the office who are texting away madly on their mobile phone instead of working. Often that's because they're solving a personal problem, which will be some kind of dispute, which is obsessing them. It makes them lack productivity, so they're not contributing to the productivity of the workplace, and they're also suffering often psychological damage as a result of dispute. So the more we can use our technical tools of the modern era to get people into the right place, to get the thing resolved without the need to go to court. Court should be really the last resort. And we can use these tools, and I think it's a vision which has legs, I hope so, and I think that's what I call the digital justice system.
And you would see the Online Procedure Rules Committee as the midwife to that, yes. Would you?
Absolutely.
Is it sufficiently resourced to do that?
At the moment, we have support from the Ministry of Justice. We have an incredibly committed team working with us. We've just appointed 20 members who don't get paid, I think.
Oh, that's right.
To the subcommittee of the OPRC, the Online Procedure Rules Committee, and they're all incredibly committed to this vision, and they're all working hand over fist to see it work. I don't think it's tomorrow, Chair. I'm sorry. I think it'll have to develop over time, but it is an objective which is genuinely bringing justice to the people in the modern era, which is something that I think, lawyers tend to be conservative. They tend to be, not politically, but conservative, and they don't like change. But I've never been like that. I believe we need to think out of the box to create solutions for the resolution of people's problems in the digital age. And the other thing we need to make sure about is that we don't assume the problems for the digital age are going to be the same problems as they were 20, 30 or 40 years ago when we were brought up as young lawyers. That's a tremendously stupid thing to do. The county court changes, the people's problems change. Actually, many of the problems are online problems, eBay problems. You know, people spend a lot of money online, and they lose a lot of money online, and they have legal rights online, which need to be rectified, and the rights need to be vindicated. So, I mean, it's a big project, but I think it's the only way forward for justice in the future. And we should raise our eyes from everything that is, you know, just possession claims or just personal injury claims, which was what it was in the past.
Practical question on that. That sounds very encouraging, and congratulations on the result yesterday of having the property cases brought into scope. What's the strategy for bringing further cases into scope of that committee? Further kinds of cases.
Well, the strategy is to gradually transfer as many types of case into the purview of the Online Procedure Rules Committee as they are digitised. So, at the moment, for example, in civil we have the OCMC, the Online Civil Money Claims, but the rules are made by the Civil Procedure Rules Committee, and that's illogical because it is a digital smart system. And so the rules should really be made by the Online Procedure Rules Committee. Let me explain the difference between the rules. The CPRC, the Civil Procedure Rules, are contained in 6,000 pages in two huge books called the White Book, something that I had the good fortune to edit for some years. It's absurdly long, completely impenetrable for ordinary people, and doesn't really meet the standards, despite the fact that it was reformed by my predecessor, Lord Wolfe, in 1999, unfortunately before the digital age had really taken hold. The idea of the OPRC is that the rules will not say things like you have to go online and give your name, because you won't be able to start the process without giving your name, and you don't need to make a rule to say give your name to the programme. Instead, it will say if you go online and bring a claim for damages in Damages Online, you will not have an order made against you without being asked to make submissions. And that is a basic premise of natural justice. And so that will be the rule. It'll be a high-level rule, and it will ensure that the whole system is operating within Article 6, within the right to a fair trial, and to ensure that justice is done on the system. Now, Colin will be able to give you a lengthy discourse on the difficulty, because Colin is our rules supremo, if I may respectfully say so, but he will give you a discourse on how difficult that is, because it is imperative that a justice system that operates in the name of the state does not do anything illegal, and it has to have a legal foundation for the way it resolves disputes. And one of the difficulties is that the programme is created by programmers who are not lawyers and probably don't have the rules embedded in their head. And so we as judges have to make sure that this programme is operating, that this platform is operating in a just and appropriate way throughout. But the objective is to have simpler rules for the court online process, to transfer all the online systems to the purview of the Online Procedure Rules Committee, and eventually to leave the civil procedure rules for complex cases in the High Court and things that actually get into a real battle in court.
Thank you very much.
May I just, having been mentioned, I feel that, can I just add one more thing to what the Master all said, which I think I hope is helpful. The way in which we can make that happen by having what we want to do and have high-level rules in this online procedural rule concept, but still have an IT system which does justice and does the right thing in the right way. One of the most important pieces of that is to have a system. You could call it a dummy system, you could call it a sandbox, there's lots of different names for it, but being able to find out how the system works without suing somebody. One of the difficulties we have at the moment is the existing digital systems. If you want to ask the question, what happens when I get to this point in the system? The only way to find out the answer to that question is by litigating, is by suing someone, working your way through the system, and eventually you'll come to a screen and you'll see what it says. That doesn't work as a way of governing an IT system. So what we need to do, and this is what we're discussing, is making sure that there is, if you like, call it a dummy version of the real thing that allows everyone to see how it works, to try it out, find out what happens at this stage or that stage of the system, so that you can be sure that it's doing the right thing. And that's not a trivial task to build something like that, but that's a crucial piece in this whole endeavour.
And that is transparency, and it allows for simplicity of rules. Yeah. So it has a double whammy of efficacy.
And maybe if I may, one more thing, just going back a little, data standards. One of the really important reasons why the Master Rolls is talking about data standards is that they're not difficult to make, and they're not expensive. They're rules. We make rules in rule committees. That we can do. Somebody else makes the IT systems. You don't have to build a monolithic computer system by setting a series of data standards to allow all these pre-action things to interact with each other. And that's a really important aspect of why this vision makes sense.
Yeah.
So I have a couple of different sort of thoughts or concerns, although possibly this just makes me the small c member of the legal profession that you referred to. But one of which is doing justice is one thing. People feeling that they have had justice is a completely and utterly different thing. And I have concerns that both of the systems that you're talking about have more scope to deliver justice than to deliver a feeling of having received it. But in terms of looking at the online rules, I mean, the employment tribunals, we just don't have anything like the volume of rules that you do in the White Book. I've always found it completely bizarre. Like, we don't have to be told that you don't give out an order until you've had some submissions. That's not even, I doubt that's in the employment tribunal rules. We just don't do it. It's just not a done thing. It's just not something that happens. So I appreciate you've got a wide variety of different case types, but some of this I'm just like, can't you just have the overriding objective to achieve justice and then crack on? So could we get to some of that? But in terms of the online stuff, have you got, looking at this, an equal number of men and women? And what do you do about engaging with people who are actually court users? Because you've got a lot of litigant in person out there, and rules that solicitors can use are not helpful.
Yeah, well, we're doing a lot of... you
I
start,
was going to say, yes.
I'll come back to whether we do justice.
Well, the short answer to your question is, as to the numbers, I don't know. But we have one of the members of the OPRC, the Online Procedural Rule Committee, specifically her focus is on inclusion. And one of the major work streams of the subcommittee that we've been talking about is an inclusion work stream, which is exactly on the point. So that is front and centre of the work that's being done. So that I hope is a positive answer to your question. Absolutely, yes.
Can I come back to whether justice is being done?
May I just address that point?
Sure.
And then, may I gently suggest that if you're not sure whether or not your committee is demographically representative in a variety of different ways in terms of disability, ethnicity, and gender, if you're not sure, then it probably isn't. And it might be worth checking.
I think it is, actually. I think he's doing himself down. But I think the subcommittee is pretty demographically balanced. I can't tell you the numbers either, but it was certainly intended to be. I really want to come back to your point about justice. People need to feel they've had justice, not just that there has been justice. I spend a lot of time trying to identify why people come to court, why people need disputes resolved. A very large number of people have a dispute that they simply want to be finished. They want the money, but they want to be finished. And they don't spend all their time thinking that the judge has done them down or not done them down. They would much prefer to go nowhere near a court, but to have a quick, economical, effective resolution of their dispute. Of course, there are people who actually require to see justice done and are sensitive to whether it has been done. Nothing I've said stops people going to court and engaging in exactly the same process as they do or did in the past to get a dispute resolved. What I'm trying to do really is pick off a series of low-hanging fruit so that you're actually, the justice system, which is jolly expensive, is resolving disputes that have no other way of resolution. Because mediation, arbitration, ombuds people, and a whole series of portals are incredibly successful. We haven't discussed automatic referral to mediation, but in the county court, with cases that have actually got to the bottom of the funnel, even now we force them to go, 32% still settle their cases when they thought they probably didn't want to go in the first place to mediation. And when they went voluntarily, it was nearly 50%. So mediation is a fantastic tool, and people come away from a mediation normally pretty happy because they've agreed to the outcome. So you're quite right. People do have to be satisfied that justice has been done and seen to be done. But I think this system achieves that for the most part, and where it doesn't, we will make sure we do something about it. Now, can I come back to the rules? This business of why do you need so many rules? Couldn't agree with you more. The idea of the CPR reforms in 1999 was to cut the White Book in quarters. It didn't work. It simply replaced rules of the Supreme Court with parts of the Supreme Court rules, which are truthfully the same thing. They're written in slightly more simple language. I agree with you. You do not need all those rules, but it's work in progress getting rid of them. But as more and more cases move across to the OPRC, and the OPRC has the kind of rule type that you're talking about, the problem will start to resolve.
Thank you very much. We've got 2 or 3 more issues, one of 2 of which you mentioned, which are mediation and CPR, and then we will end up on AI. So if you could bear with us for another 10-15 minutes, that would be very helpful. Warinder.
Yeah, so Geoffrey, you mentioned the White Book. I agree with you. You've described it as being too long and cumbersome. I never enjoyed reading the White Book, even though I had to do my job. So you have suggested a foundational reform. What would that involve? So what is going to be that foundational reform? And also, do you think that reform of the CPR should precede any further digitisation?
No, I think the CPR is going to remain for the non-digital environment, but more and more cases will be brought and resolved in the digital environment, subject to the OPRC rules, which will be simpler and easier to follow. I haven't suggested abolishing the CPR for non-digital cases. I think that is a big job. Personally, I think actually the problem with the White Book is that it has too many things that are not rules. So it's very useful for somebody who's looking at it every day and knows where to find everything, except that it's written in 10-point, which I personally can't read. But apart from that, it's very useful, but it should be arranged in a quite different way. What most people want to see is the rules. Now, the rules are only a book, a small book. They're not huge, but they're too big probably. I don't think we should engage in a foundational reform. What we are doing, what Colin is doing, is cleaning them up. We are, what's it called? Simplification. So we are simplifying and removing redundant rules all the time. Unfortunately, the White Book is published by a commercial publisher, and they include all those notes because it's their view that those notes are wanted by the people who buy the book. But actually the rules are getting simplified all the time.
I mean, if I could just mention that. So we started a project to do that 4 years ago, and we are working through, and we have been working through the rules to identify bits that we can get rid of, from the main rules. And first of all, the White Book isn't the rules, as the Master of the Rolls said. I mean, it's a constant frustration, frankly, for me in working in the CPR to be criticised about the White Book, because the White Book is full of all this stuff which isn't the CPR. It's useful stuff, I'm not saying that it's not, but it isn't the CPR. And the CPR is really in two parts. It's not written this way, but it is. There is the central rules which govern civil justice, and there aren't that many of them. There's about 40. And then there is an extra stuff about enforcement, which is very important but rather different. And then there is a whole lot of other stuff about special cases. And everybody wants a special case. And every time somebody comes along, if I may say sometimes often government comes along and says, we've got this special case, we need special rules for this special case. Instead of fitting it into the existing rules, we end up with a whole new practice direction to deal with some special case. And then there's another special case and another special case. And that's the explanation for why the rules are in the state they're in. Because if you're dealing with anything other than the very ordinary case, you're flicking back from part so-and-so and part such and such. But we've got rid of, I can't remember the numbers now, but we've certainly got rid of about 6 whole practice directions, which I get very excited about. I mean, it's a bit nerdy, and I apologise for that. But those are great long chunks of text, which when somebody actually sat down in our rule committee, looked at the rule and looked at the practice direction and realised that most of what was written in the practice direction was sort of the same thing that was written in the rule. And if you changed the rule a little bit, you could get rid of it altogether. And that's got to be worthwhile, and we are doing that.
Thank you for that. Can I ask you about fixed recoverable costs? In more than 30 years of practicing as a PI and clinical negligence lawyer, I absolutely agree with you. I think every single one of my clients wanted an early resolution to their claim, a quick settlement. And you did mention that legal aid is much less than it was before, with an increase in litigants in person. I've always felt that having more litigants in person is not necessarily a good thing, because judges and courts spend longer trying to help them out so that they can deal with their cases, which is why I've always felt that legal representation in certain types of, certainly the kind of cases that I dealt with, was always necessary. So I think fixed recoverable cost actually leads to access to justice as well, because there have been cases where, for example, birth trauma cases, mental health cases resulting in suicide, fatalities in older people, younger people, where the claim is worth less than £25,000, those cases have been subject to fixed costs. And I've had the Society of Clinical Negligence Lawyers contacting me, saying that they've put forward proposals as to what could be an alternative, such as having a roadmap and then having an agreement with the other side as to how the case is to be dealt with. I'm particularly concerned about claimants who are going to be vulnerable when they seek legal help, when defendants will always have qualified lawyers representing them. So I just wanted to know from yourself, Sir Geoffrey, what is the rationale behind the reforms to the fixed recoverable cost? I know it's to save cost, but are we actually saving costs? And is that at the expense of access to justice? And do you believe that fixed recoverable costs have been successful in encouraging access to justice?
First of all, it wasn't the Judiciary that introduced fixed recoverable costs. It was the last government. I think it's too early to say how successful it's been, or indeed what the access to justice issues thrown up by it have been. I think one of the problems, particularly with personal injury litigation, is that it's been very expensive relative to the amount of damages recovered at the end of the day. And that is obviously not a good thing, because one of the central parts of justice has to be proportionality. And you simply cannot justify spending an endless amount of money, however seriously the parties regard the case, if the case itself is only worth a very small amount of money. So you have to have a proportionate system. And I think fixed recoverable costs attempts to achieve proportionality. I think we have to wait to see whether it does that, or whether the concerns you are raising are valid on the evidence. So I would leave it a year and then look again. And I would happily come back and talk about it when I've had an opportunity to think about it. What do you think, Colin?
Just to add, I mean, we could discuss the detail of fixed recoverable costs if you'd like. We can do that, but I'm not sure it's necessarily all that productive. But the important thing, to pick up what the Master Rolls just said, is that when the Rule Committee passed the rules to bring in the new fixed recoverable costs scheme, we, the Rule Committee, specifically said that we wanted to have a stock take once it had been going, which is not something the Rule Committee itself has ever done before, as far as I know. And the stock take was originally going to be scheduled for the beginning of this year, but the number of cases going through the intermediate track, which is part of the fixed recoverable costs, as I expect you know, is still relatively small. And so the decision was made at the meeting in March to say that the stock take would take place in the summer, and probably in the autumn, October, just to make sure that there's actually some information about what's happening. So to exactly the point that the Master Rolls and you've just made, we need to look at it. We absolutely know that.
Yeah, I mean, I totally take on board the point about proportionality. I think that's important, but my concern is about access to justice. And with again, you know, looking at all the clients that I've dealt with in the past, a lot of them just want justice. They want an acknowledgement of the fact that they've been wronged. They're not necessarily wanting to have huge amounts of compensation. And a lot of these claims that are considered to be low value are quite complex claims where you do need legal expertise to represent the claimant well and to achieve a resolution of the claim quickly using legal expertise. So I think that is perhaps overlooked, but I do again appreciate it was the previous government that brought these rules in. So as a final question, I just want to put this forward that we've spoken about delays in the county court. Do you think that delays in the county court have undermined the effectiveness of fixed recoverable costs?
Probably not yet, and I don't think enough cases have gone through to see that. I think it is absolutely imperative that we exclude delays, and we'll only do that by digitising and putting things online. And the sooner we do that, the better. Unfortunately, it's many of the smaller cases and cases brought by vulnerable people that are not digital, because they will bring things on paper, litigants in person particularly. Yeah. So
Clin Neg would be brought by a solicitor, you would have expected normally, and they would be damages claims that should be in the damages online system. And I think if I'm right, for clinical negligence specifically, the only fixed recoverable costs, they only apply if causation is admitted.
Yes.
Which is an exception for other things. But that doesn't,
Thank you very much. Lindsay.
Thank you. Away from rules and back to humans, if we may, I'd like to talk to you about mediation and alternative dispute resolution. And I think since you last appeared to the committee in June 2023, there's been major developments in the use of mediation for civil justice, and I know we were learning about that yesterday in relation to the mandatory requirement for mediation for civil claims under £10,000 when we were in Northampton at the business centre, that they were teaching us about that yesterday. I found that really interesting. I'm just wondering whether you think that whether mediation is being used in the county court enough at the moment, and whether mandatory mediation should be expanded for any particular parts of the system.
I do actually. I think mediation is something that should be tried, and what I used to call repeated attempts to settle, interventions to try and persuade people to settle, try and get them to reach agreement without the need to spend more and more money and take more and more time and cause more and more upset, is a jolly good thing. I'll give you one example, a case in the High Court where mediation has been prevalent but not much used for many years. A judge ordered mediation under the new jurisdiction established by the case of Churchill, in which both Colin and I sat, where we said it was open to the court jurisdictionally to require parties to mediate their case. And the parties were outraged by his intervention and said that they had no intention of settling the case. The case was unsettleable and it required judicial resolution, and it was completely outrageous that he was even having the temerity to suggest that they should go to mediation. And he said, well, you may say that, but I'm saying that you should go to mediation. And he ordered them to go to mediation, and the case settled. And both parties were saying exactly the same thing. And a long trial was averted by this settlement. So mediation is something that people should, I think, be required to consider. And in small claims, it's also very successful. So the kind of mediation we're talking about is an hour on the telephone, not to a lawyer, but to an HMCTS mediator who's trained. And it's really not going to be, I think, deleterious to the interests of justice to require warring parties to spend half an hour on the telephone or an hour and having it suggested to them that they might actually have been unreasonable in demanding £1,000 when their claim was only £500. So, yes, I do think we should have more of it. It's something that is always controversial because we have this idea that every case should be resolved by a judge in a court, a lovely panelled court, as it was in the 19th century. But the truth is that's very expensive, and people sometimes can be brought to a satisfactory resolution by a whole variety of mechanisms. And particularly in the modern environment, you can use digital interventions, you can use even AI potentially in the future. And I think we should open our minds to every possible way: early neutral evaluation, mediation, consensual arbitration, any kind of way of bringing speedy resolution so people can get on with their lives. And, you know, sometimes dispute becomes an end in itself, and we as lawyers mustn't make that worse. We must make it better.
Do you think there are any... Do you have any concerns about the access to justice side of things in terms of mediation if one party has had the benefit of legal advice before going into mediation and the other hasn't? Are there any safeguards if you do have any concerns?
Well, the mediator has to be properly trained so they understand that. I think it's very problematic in family cases where sometimes a vulnerable spouse, often a woman, will not have legal advice and will effectively in mediation be bullied into giving up property rights that shouldn't happen. But that's not what we're talking about here. Here we're talking about probably two litigants in person, both of whom have very fixed ideas about their case, and somebody standing in between and saying, come on, don't be stupid, £500 was the amount you were due, not £1,000, why don't you settle? And of course there should be no bullying, of course there should be no pressure, and of course there should be no inequality of arms, and mediators must be very clear about that.
If it was to be expanded, you would want to see some safeguards for the
well,
sorts
there
of
already
cases
are.
that would be...
Yes, I mean, just because they're being forced to go doesn't mean they're being forced to settle.
Thank you. And you mentioned the use of early neutral evaluation within the county court. You touched on that a moment ago. I'm really interested in that. I'm just wondering whether you think that should be used more, and if so, how it should be used, and again, whether that in itself would be a useful tool in terms of access to justice where somebody isn't represented.
I close my mind to no kind of dispute resolution. I think early neutral evaluation is excellent in some cases. 2, 3, 4 years ago, the Civil Justice Council made a report about small claims, and there were a lot of pilots in some county courts basically suggesting that all small claims should be listed for half an hour in front of another district judge, for the district judge to suggest early neutral evaluation, or perhaps put more robustly, bang the heads of the parties together in a non-physical way to suggest a settlement. That worked in a large number of cases, but it's very judge heavy in terms of resources. And the problem was that it also had the effect of entrenching some of the people who didn't settle and making the dispute even more difficult to resolve. I think it's good for some cases and probably not for all cases. One of the important things about dispute resolution is to understand that it's horses for courses. I'm perfectly comfortable with requiring parties to go and spend an hour on the phone to a mediator, at which they're perfectly capable of saying no. I'm less comfortable with saying that every case should be listed for a second hearing, which bungs up the courts. It has to be shown on the evidence then that it really is valuable and an appropriate course. It could be. There were people who thought it was, but some of the outcomes were not as exactly as we'd expected.
Just to elaborate on that, the thing that made it complicated is that it wasn't clear that the cases which did settle at that stage were the ones that would have settled anyway. And so the question then becomes a resource allocation question, because was it worth the resource? If you look at it, and this is depersonalising it, which I don't think is acceptable, just be clear about, but just at that level of resource allocation, that was a question, whether it was actually worth that kind of resource. And maybe the answer is yes, because ultimately settling earlier is better, but that's the sort of difficulty which these things throw up.
How would we decide which cases were suitable and which cases weren't suitable for certain types of resolution?
Well, particularly with small claims, it's very difficult because basically you have to have a system in a court that says every case is going to be listed or not. And overall, the outcomes that we saw in the pilot was not absolutely clear that that was a good use of judge time. But yes, I mean, of course, judges should have in their minds the possibility of early neutral evaluation for particular cases that they see. And you should be able to do anything that is appropriate to reach resolution if you can.
Judge-led then?
Yeah, but
on a case-by-case basis.
When it gets to a judge, I mean, my digital justice system has hundreds and thousands of cases that resolve long before you get anywhere close to a judge. The problematic ones are the ones that get into court.
Do you think the professions are signed up to your vision of the widest possible dispute resolution? I'm conscious we're celebrating tomorrow night here the 200th anniversary of the Law Society, and lawyers are sometimes wedded to their histories.
I hope so, is my answer.
Thank you. I won't press that any further. As the very last question, you mentioned just there in the context of dispute resolution, artificial intelligence. How do you think artificial intelligence can affect the work of the county court and improve it in the near future?
I'm going to let Colin start.
Okay. Well, there's two different things. Artificial intelligence as an assistance, not talking about artificial intelligence deciding cases, but just as a tool. And it seems pretty clear that it's well worth looking hard, and we are looking hard, starting very baby steps, small steps, to see if we can use artificial intelligence to help judges. So, for example, the thing which I would really love to do is this. If you're a senior judge, most of the cases, almost every case you get, comes to say me with a piece of paper on the front page in which someone has written a summary of what this case is about. And those summaries are very good. They're not perfect. They don't have to be perfect, because I'm not going to decide the case reading the summary. The point of the summary is it makes it quicker for me to read into the case. But we don't have the resources to provide that service for our district judges or even our circuit judges. It takes resources. But we know that these AI machines are good at summarising. So there doesn't seem to be any technical reason why we couldn't have a system in which for every case a judge had in the county court, they were presented with a summary of the same kind for the same purpose, and it won't always be perfect, but it will orient them in what the case is about. They can see it. If you imagine, I'll tell you another sort of war story, if you like. It's 5 o'clock in the afternoon. You want to go home at 5:30. There are, and take a paper world. There are 5 piles of paper on your desk, and this is a real example. and you're a good person, and you want to do one before you go home. The problem is you don't know, without opening the blessed file, which is which. But if you had a summary on the top, you would. And it's as simple as that. And that's the kind of thing that we could use AI for, and we are looking at trying to see if we can use it to summarise cases. That's just one example. Transcription is another one. If we could use AI to transcribe material from oral hearings, that would be really, really helpful, and we're looking at that.
Let me tell you one thing that I was very taken by. I gave a speech on AI at a law tech conference a month ago, and a young woman barrister practicing in the Employment Tribunal gave a speech about how she used AI in every single one of her cases to create chronologies and lists of participants for the court. She checked them over. They were done by AI, but she then checked them over. She said, I've set all this up on my computer because AI is not something that is done to you. AI is a tool that you have to use for the kind of work you do in an appropriate way. And she said, I'm an employment barrister. I do a lot of cases that are quite similar. I've set up tools using ChatGPT, and I save every week of my life 5 hours of my time by doing those things that give me a head start in my cases. And that's not risky because she's checked everything. It's not dangerous because she's checked everything. It's just time saving. And we would all use a Hoover instead of sweeping the floor with a dustpan and brush. And so we should consider how we can use AI to save time and to make sure we get better, cheaper outcomes for the people we serve. We are not here to do justice for ourselves as judges. We are doing justice for the people, for the citizens, and for the business of this country. And I think it's incredibly important with AI, actually with everything that we've talked about, to understand that.
Thank you very much. That gets to be, is it?
Yeah, I'll make it really quick. Thank you, Chair. So we did have a presentation at one of the previous Select Committee meetings of how lawyers can use AI to make their job really easy, because AI would tell you what the next step you need to undertake in your case. Do you foresee judges using such a facility in the future?
Well, I think judges will use AI for all sorts of things. Different judges will use it for different things. The critical thing is they follow the guidance that we have issued as to what you must not do. And what you must not do is write a judgment with AI and then give it out as your judgment. You must write your judgment yourself. But it can save time, and if it can save you time in the particular work you do in an appropriate way, then by all means. I think it will come more and more, and there will be greater acceptance and understanding of how to use it. I think it's terribly important with these things not to be frightened of the future, not to be frightened of our own shadows. Because in life, worlds have changed, commercial situations have changed, everything changes. We're all still here, luckily. And I think we will still be here when we use AI, and we will still be sensible when we use AI, as we have been in the past. So I just caution against dramatic prognostications as to the future when we talk about AI.
We leave that to Foreign Affairs, yes. Thank you very much, both of you, for attending today. That's a suitably positive note to end on, and you've given us a lot to think about, a lot to question the MOJ ministers when we next see them. Thank you very much indeed for your time and your expertise this afternoon. I'm going to close this afternoon's session there. Order.